Hey everybody. Hope everyone is doing well and is off to a great start this week. It's hard to believe that we're officially halfway done with the course and we're entering into Module 5. and Time just is going by fast. So hope everyone brackets are still doing well. I actually was one team away from a perfect Elite Eight, and then everything went downhill from there. So, frankly, at this point, it doesn't matter if KU's not in it. I don't really care at this point. But anyways, we had an interesting week. For Module 4, we discussed, if you might recall, medical records, and we talked about HIPAA, the privacy rule. I talked a little bit about the security rule and the enforcement rule, and the discussion question this past week was specifically geared towards the privacy rule. And I think you saw, hopefully you saw the announcement that I posted a few days ago. I think it was on Thursday. So you had that context while you were responding to other posts if you hadn't done so already. With respect to the rule that we were really gearing towards. I have looked at a lot of the discussion posts. I graded a few this morning, and I think one thing that that I'm just looking for in these initial posts is and I don't expect, I think I said this before, I don't expect anyone to know these HIPAA rules inside and out, but or any rule for that matter. What I'm really driving towards is, are you citing a rule in your analysis, and are you applying facts to that rule? I think that's the important piece, the important takeaway from this class, particularly with respect to this discussion question, because I think it really exemplifies the need for that type of analysis. You had a couple different scenarios in that fact pattern, and you were asked to analyze whether or not there was some sort of HIPAA breach. The question is, what is a breach? And so I posted the link to the breach notification rule, and this is the interesting part of this analysis, is that I think intuitively or instinctively we think, all right, well, someone looked at somebody else's medical records, maybe said something they shouldn't have to a supervisor, and therefore it's a breach because the patient didn't consent to that use or disclosure, or it was a mistake and therefore it's a breach, whatever the case may be. Well, it's a good insight, but it needs to be backed up by some sort of rule that has to be incorporated into that analysis. And hopefully you got a chance to look at what I posted, because the term breach is a defined term that's really not that simple. In fact, there are multiple factors that need to be considered when determining whether a breach has occurred. And I believe there are 4 different factors, including the extent that any sort of improper use or disclosure was mitigated, or the effects of that improper use or disclosure was mitigated. So there are 4 factors, and then there were 3. I believe there are 3 exceptions to what may be considered a breach, including the inadvertent use or disclosure. So, anyways, so I think the point is, it's important to use a rule that's specific to the fact pattern, and then use that in your analysis and apply the facts to that rule. So enough about that. If you have any questions about that, please, of course, let me know. We talked medical records. Remember that there are all kinds of governing agencies that regulate uh, everything under the sun related to medical records, from where they're stored, who should store them, how long you keep them, uh, both the federal HIPAA laws and state privacy laws related to use and disclosure of and security of medical records and protected health information. So there's a lot to consider with respect to medical records, and that's why you have health information management experts out there, and that are either employed by or consult with larger health systems and medical facilities. So all the regulations certainly keep a lot of people employed. So there's that. This week, you'll notice in the discussion question, it's related to sort of a discrimination issue in the healthcare setting. Now, I personally don't consider that to be a healthcare law issue. I consider that to be a labor and employment issue. But one thing that, if you haven't seen already, you will certainly see that in the healthcare industry, that and that's a great thing, in my opinion, about healthcare law, is that it really encompasses so many different areas of law. And you could, from the end of life issues like advanced directives and DNRs and living wills and things like that, to this sort of issue with respect to employment discrimination, to real regulatory fraud and abuse sort of issues, and malpractice issues, and it's just kind of litigation issues, reimbursement issues. It's really it really encompasses about every area of law you can imagine. So that's the great thing about healthcare, and just it's never boring, in my opinion. This week I wanted to talk a little bit about the business of healthcare, and I'm going to post, along with this video, I'm going to post an article that is, in my opinion, really is a great article that discusses how physicians get paid, and sort of the business side of healthcare and the economics of healthcare. And this is this is more of the healthcare law that I practice. The just sort of the fraud and abuse, the regulatory side, the transactional side, the economic side of healthcare is something that I do quite a bit of. I haven't done really a malpractice or been involved in a malpractice case in quite a while. So while that, I think, is an important piece in healthcare related to risk mitigation, which is something we discussed, understanding the elements of a malpractice case and how to analyze that. I think another really important piece, especially in today's healthcare environment, is the business of healthcare and how that evolves and how that affects everyone in the industry. So first, on the economics of healthcare, which is always a big topic of discussion. And if you go to CNN or go to whatever your news source is, you'll see that it's coming up again very prominently in the news as we head towards another election cycle. So it's, of course, healthcare is a very politicized issue, particularly related to costs and economics and access. But really, there are a handful of things to point out with respect to the economics of healthcare. And it's really how medical facilities, providers, suppliers get paid. There are different types of payers. There's the private insurance for your employer group health plans, which are your PPOs, HMOs, EPOs, self-funded ERISA plans, which I do a little bit of work with, and then your healthcare exchange plans, which I've done quite a bit with, and which is kind of an interesting curveball with respect to kind of the payer mix, having these because of the subsidies, quasi-governmental plans in the mix, which also act as commercial payers. But and then you have your government programs, like Medicare, Medicaid, Medicare Advantage, managed Medicaid, TRICARE, the Federal Employee Benefits Health Program, and others. So why it's important to make that distinction is the regulatory structure that governs both of those, both the commercial payer side, the government funded program side, are very different. So for example, False Claims Act, Federal False Claims Act issues really are outside the purview. Private payers, commercial payers, Cigna, United, Anthem, things like that, purely private employer group health plans, outside of the purview of the Federal False Claims Act. Now, a lot of states have, I don't know about a lot, but some states have what we call all-payer statutes, and so it really extends the Federal False Claims Act to all payers. And so while there may not be any liability under the False Claims Act for commercial payers under federal law, there could be state liability under some all-payer statute. There are ACOs, accountable care organizations, that you may be familiar with, or the Medicare Shared Savings Program, where, and frankly, in my opinion, this is the future of healthcare and how healthcare will be structured, which is sort of this population health, shared savings, integrated care type model, where you have a bunch of different specialty and primary care providers coming together to treat a particular set of patients, a defined set of patients, with the goal of quality care and cost savings. And so that's what you have with things like ACOs or Medicare shared savings programs. I think these value-based arrangements is something that we'll see a lot more of, and fee-for-service arrangements are dying and will continue to die, I think, in the future. So let's talk about the business of healthcare. First, there's this thing called the corporate practice of medicine doctrine, which many states have adopted either through statute or through case law, but others haven't. I think Florida is an example of a state that does not have the corporate practice of medicine doctrine, but there are many others that do. Colorado is one of them. And basically it says that physicians only physicians can practice medicine. And what that means is that you can't have a physician employed by a corporation, say Target or Walmart, to practice medicine, because the Walmart or the corporation is not a professionally licensed individual who can practice medicine. Only physicians can. So to have a corporation to practice medicine, a physician has to own it. Typically, that the laws vary from state to state, and so what you'll have is a professional limited liability corporation, or a professional limited liability company, PLLC, or a professional company, PC. And that's how physician groups are formed. Or it could be a sole proprietor, a sole physician operating under that entity. So, and so that's important particularly in transactions, because you, as I'm hearing myself speak, I can imagine how incredibly boring this might be. So hopefully it's not too boring. But essentially, you can have a corporation, a C corp, purchase a professional entity in many states. That would be contrary to the corporate practice of medicine doctrine. So a lot of times, the way we structure these deals is what's called the friendly physician model. So you could have, let's say, Corporation A wants to acquire a physician group. Well, Corporation A it can't, because it's a corporation. It can't purchase a physician group. So what it might do is it might employ a physician who owns, or may not employ the physician, but it would engage a physician who owns this professional entity, this group. It would own it entirely, own all the shares in this group, and then there would be like a stock restriction agreement between the physician and the Corporation A. So the physician couldn't just go sell the group. It would be under some pretty tight restrictions. And then there would be a management services agreement between the Corporation A and the group. So that's how typically the Corporation A would get the revenue out of the group. So that's a pretty basic friendly physician model that works in most states. Anyways, that's I'm sure that's incredibly boring, but that's typically how acquisitions of medical groups medical groups occurs, particularly with larger corporations or health systems. So I am going to talk a little bit about IPAs and how that works. IPA stands for Independent Physician Association, and the purpose of an IPA is I have a couple of clients who are IPAs, and basically its purpose is to form a network of providers and to contract or negotiate contracts with payers on behalf of the provider members who are part of the IPA. So the IPA, that's its primary function. So I represent an IPA that has many multi-specialty providers that are part of its group, part of its network. And the IPA contracts with your Uniteds, your Cignas, at a capitated rate, meaning basically a per member per month fee for each patient within its population. And then it contracts with the IPA contracts with the provider members at a fee for service rate. And so for example, the IPA will contract with United for $100 per patient per month. And then it'll contract with a primary care provider who's part of it, that's part of its network, for a fee for service sort of model. So $15 per clinic visit or $20 per x-ray or whatever it is. And so then the providers that are part of that network, they'll send in their claims to the IPA. The IPA will review and pay the claims. And so the IPA's incentive is to reduce costs, obviously, and to increase quality care. So it'll come up with programs in order to do that, because the less it pays out, the more profit it has from its capitated arrangement with United. So that's essentially how IPAs work. Just a couple other kind of fraud and abuse regulatory laws to be aware of, and you may already be aware of them. Are the big ones: anti-kickback statute and the Stark Law. So the Stark Law, and this is a great example of the importance of knowing rules in an analysis, because the Stark Law is also known as the Physician Self-Referral Law. So it basically says that a physician cannot refer a patient to a healthcare entity in which that physician has an ownership or has a financial relationship. So Dr. Rhodes, I own a laboratory, okay? And I can't, let's say I own the laboratory. I can't just start sending all my patients to that laboratory unless an exception applies, because I then benefit from every patient I refer to that laboratory. So that's essentially the arrangement that the Stark Law is trying to prevent. So there are other factors. So a physician, there has to be a financial relationship. Financial relationship can either be an ownership interest or a compensation arrangement. And it has to be a referral for what's called a designated health service. And so there's a list of specific services that are included in this definition of designated health service. So not every referral under the sun is prohibited by a Stark Law, only those that are within that definition of designated health service. And it has to be for services that are payable by the Medicare program. So those are all important questions that you have to ask and answer in performing some sort of Stark analysis. Now one other thing, Stark Law is a strict liability statute, which means unless an exception applies, and there are many exceptions, then it doesn't matter if you intended to violate, it doesn't matter if it's a technical violation, if there was a signature missing that caused an exception not to apply. If there's a violation, no exception applies, then you violated it, and you have to remediate the issue. The anti-kickback statute is a little different. It's anti-kickback statute is actually a criminal law, and there are civil penalties associated with it. But it basically says you can't give any, and it doesn't apply to just physicians. You can't offer or receive anything of value in exchange for a patient referral that's paid for by the federal health care program. So I can't go to, let's say, Kayla in the class. I can't go to Kayla and say, hey, Kayla, you're a doctor. I have a bunch of people I know who are looking for a doctor. How about I refer them to you, and you give me 25% of what you make from them? That is illegal. It's illegal, it's illegal under the anti-kickback statute if all these people I know that I'm referring are enrolled in some sort of federal health care program. Now, some states have extended that to all payers. So it's not just applicable to federal health care program, it's applicable to all payers. That any sort of kickback in exchange for patient referrals would be prohibited. So that's illegal for me to offer it. It's illegal for you to solicit it. It's illegal for you to receive it. So it's two ways. You can't offer it, receive it, solicit it, induce any sort of inducement. It's all illegal. So the key difference, there are a lot of differences between Stark and anti-kickback, but a big one is that because anti-kickback statute is a criminal statute, it requires some level of intent. You have to prove some level of intent to have a violation. So you basically have to violate it knowingly. Not that you knowingly, it's not specific intent, meaning you don't have to knowingly violate it. You have to knowingly offer or receive patient referrals in exchange for a kickback. So there has to be some level of intent there to do that in order for there to be a violation. So anyways, hopefully you're still awake, and I just realized how incredibly boring that might be, but this is, and frankly my kids think I have the most boring job in the world because this is the stuff that I deal with every day. So it takes about 15 seconds of me explaining what I did in a day for them to zone out and become completely disinterested. So anyways, I hope everything's well, and you guys have a great week. I love the engagement. I love the discussions. Just want to continue to emphasize, even in this week's discussion related to discrimination, emphasize the importance of the analysis. Again, I'm not super concerned about the outcome or the conclusion, as long as it's a reasonable outcome, a reasonable result based on an analysis, which includes citing a rule, applying facts, and coming up with your conclusion. So, as always, I'm around. Let me know if you have any questions or want to talk through anything, and I hope you have a fantastic week. Have a great one. Bye.